Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 400 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Assault Lawyer, Southern Illinois. Assault is subject to a wide range of punishments under Illinois law, including substantial prison time. The Southern Illinois criminal defense attorneys at Combs Waterkotte have handled over 10,000 cases, including many involving allegations of assault and intimidation. We have the legal knowledge and resources to fight for an acquittal, plea deal, or fair sentence in your assault case. Assault offenses in Southern Illinois. Under the common law, battery and assault were separate crimes. Battery involved the intentional and unlawful application of force on another person's body. Punching, pushing, or throwing an object at someone would qualify as a battery. By contrast, assault constituted either attempted or threatened battery. Specifically, it included unlawful and intentional words or acts that placed another person in fear of an imminent battery. Illinois has maintained a distinction between assault and battery. Under Illinois law, these violent crimes have different elements and punishments. Assault and intimidation statutes in Illinois. Illinois has several statutes that prohibit threats of force or bodily harm, including the following. Assault. In Illinois, assault occurs when someone knowingly engages in conduct that causes another person to reasonably fear a battery. The conduct can include words or actions. For example, saying, "I'm going to break your nose," may constitute assault. The imminence of the threat is important. Yelling it from several feet away might result in assault charges, while texting it to the victim might not. However, even if you escape assault charges, less immediate threats sent electronically or through the mail may expose you to other charges. The accused must engage in the conduct knowingly. That means they must be aware of the circumstances and facts that could bring about the prohibited result. For example, the accused must know that the other person is present and that their words could be heard. They must also know that their acts or words will trigger fear. Aggravated assault. Aggravated assault happens when someone commits an assault under the following aggravating circumstances: on public property, a public place of amusement, a sports venue, or a church; against a disabled or elderly person; against a teacher or school employee on school property; against a park worker on park grounds; against a community policing volunteer, private security officer, or utility worker; against a first responder; against a police officer or a probation agent; against a corrections worker or officer; against a government employee; against a transit worker or passenger; against a coach or sports official; against a process server; using a deadly weapon, an air rifle, or a replica firearm; wearing a hood, robe, or mask; by committing a drive-by shooting; by pointing a laser gun sight attached to a firearm; using a motor vehicle, causing the fear of being struck; while recording the offense to distribute the recording. Prosecutors must prove that the accused committed these acts knowingly. Thus, you don't necessarily commit aggravated assault because you made threats in a parking lot dispute against someone who turned out to be an off-duty police officer. Instead, they must be performing their duties. Moreover, you must commit the assault to prevent them from carrying out their duties or to retaliate against them for performing their duties. Intimidation. Intimidation occurs when someone threatens another person to cause them to perform or refrain from performing a certain act. The threat can include the infliction of physical harm to the listener or another person. The line between assault and intimidation isn't clear-cut. However, intimidation is a felony in Illinois, while assault is typically a misdemeanor. As such, a common strategy for those charged with intimidation is to argue that their intent wasn't to cause the other person to act or refrain from acting. For example, if you were to say, "I'll punch you in the mouth if you come one step closer," prosecutors might interpret that as intimidation to prevent the other person from approaching you. However, your criminal defense attorney could argue that your words were simply bravado and not truly meant to influence the other person's behavior. Aggravated intimidation. Aggravated intimidation happens when someone commits intimidation in the following circumstances: to further gang activities, to prevent someone from becoming a community policing volunteer, against a civilian reporting a forcible felony to the police, against a police officer, corrections officer, firefighter, or community policing volunteer performing their duties. Aggravated intimidation is one of the most serious felonies in Illinois that doesn't involve physical harm. Additionally, assault and intimidation offenses can provide the basis for a hate crime conviction. Hate crime is a separate offense that occurs when someone commits assault, aggravated assault, intimidation, or aggravated intimidation while motivated by any of the following characteristics of the victim: race, color, creed, religion, ancestry, gender, sexual orientation, physical or mental disability, citizenship, immigration status, national origin. This crime occurs even if the accused was mistaken about the victim's identity. For example, if a person assaults someone because they think the victim is Muslim, it still qualifies as a hate crime even if it turns out that the victim was a Sikh. Possible defenses against Southern Illinois assault charges. Your criminal defense attorney may use any number of criminal defense strategies to challenge your assault charges, including the following: self-defense and defense of others. Illinois allows you to use threats or force to defend yourself when you reasonably believe it's necessary to prevent someone from using unlawful force against you. Thus, you may be justified in telling someone that you'll hit them unless they let go of your clothing. The state's self-defense statute also allows defendants to raise the defense of others. Specifically, you can use threats to defend someone else from unlawful force. Defense of property. You're allowed to threaten someone whom you reasonably believe has entered or is entering a dwelling unlawfully. For instance, you could invoke the castle doctrine if you were charged with aggravated assault for pointing a gun at someone rattling your home's doorknob to see if it's unlocked. Lack of intent. Assault must occur knowingly. If you didn't know that anyone else could hear your words, you might lack the intent necessary for a conviction. Similarly, you can raise this defense if you were joking, and any reasonable listener would have interpreted your words as a joke. How we can defend you from assault charges in Southern Illinois. Assault cases often hinge on how prosecutors and jurors interpret the accused's words and actions. That means we need to understand the whole story, including what occurred before the alleged assault and the context of your conduct. We'll listen to your side of the story and interview any witnesses who saw or heard what occurred. Our skilled team will identify the potential defenses you can assert and present the supporting evidence to prosecutors to negotiate for a dismissal or a fair plea deal. If we can't obtain one, we'll advocate aggressively for you at trial. Contact Combs Waterkotte to discuss your Southern Illinois assault case. The punishment for assault may range from probation and community service to decades in prison, depending on many factors. Our attorneys can gather mitigating and exculpatory evidence to push for a fair outcome in your case. Contact us online or at 618-88-CRIME today to discuss your charges and the defenses we can raise on your behalf.